Hey gang, Sally here. Hope you're having an amazing and fascinating day. I know I am. I'm coming to you from the same location where I've been in northeastern Maine for about a week and a half now, leaving in a day or two. And as always, thank you so much for watching my videos. I'm really glad you're here, and I've just been absolutely thrilled. I seem to be gaining momentum both in terms of number of views and in terms of number of viewers. So thank you to everyone who is watching my videos. Today, I've got one of these kind of contentious subjects, which is about filming in national parks um, for YouTubers in particular. And it's an interesting subject, and it's been quite contentious. There have been lawsuits about this. There's a couple of YouTubers that had a lawsuit, and I actually didn't dive into that one very deeply because I got caught up with somebody who was not getting a commercial filming permit and got cited after the fact, went to court and won, and then it was overturned. This is a very complicated amount of stuff that's going to be going on in this video. So we're going to roll the intro and then we'll get right into it. Thanks for being here. All right, let's start off with the disclaimer. I'm not a lawyer. My father was one. I'm not giving legal advice. I'm not telling you what you should do. I'm not even going to tell you what I do. I want to tell you about all the cool stuff I found out about while I was diving into this subject, though. And it's pretty big and hairy and thorny. And there's going to be a lot of numbers. No math. We're not doing math in this video, guys, so hang with me. And stay tuned all the way to the end because I went down a rabbit hole a few days back when I started researching this in depth to begin with. And I came to the conclusion that I was completely and totally wrong about what I thought based on what I was able to find in the information I was able to find online. And then I kept thinking about it and thinking about it and thinking about it. And I thought, well, that can't possibly be right. And then a video popped up in my feed from Travels with Rob. Now, for those of you who are friends of mine, that's not Rob Travels with Dottie. This is another guy entirely. And I'll put a link to his video up here someplace, wherever it goes. I don't know. Uh, but it was really quite interesting. And he went through the effort of trying to do this the right way, only to have the National Park Service tell him, oh, yeah, you don't need a permit. You're fine. So I'm going to have to put my glasses on. I think there's a lot of detail in this, and I want to make sure I get it right. And so I'm not going to necessarily be looking right at the camera either, because I'm going to be looking at what I've got on the screen that I want to share with you. So we're going to start off with the lawsuit that was Price v. Barr. So this filmmaker named Price sued the federal government, the Attorney General, and the National Park Service because he was cited after he had done a screening of his independent film. Um, he was cited by National Park Service officers and thought that that was completely inappropriate and that he had a First Amendment right to be able to move forward this way. So one of the first things that I found out from reading the case docket about this is that the filming regulations not only cover the National Park Service, which is what everybody talks about, but it's important to know that it also includes the Bureau of Land Management and the U.S. Fish and Wildlife Service. And so in accordance with subsection 100.905 of 49 CFR subsection 5.1, the Department of the Interior implementing regulations require a permit for commercial filming. The DOI regulation defines commercial filming as, and we're going to come back to that, because really and truly, I think that they've got some issues with this, even though they managed to get this decision overturned later. Because the DOI regulations specifically exempt news gathering activities from the permitting regime. And for the purposes of 43 CFR Part 5, News is defined as information that is about current events or that would be of current interest to the public gathered by news media entities for dissemination to the public. Well, you can't just stop there. There's more to that. We're going to get to that kind of near the end of this. But this is where it stops in the suit that was filed. So we're still talking about Price's lawsuit at this point. And CFR is Code of Federal Regulations, for those who don't know. And so I'm citing law. And I've gone out and I've looked up all of these laws myself because I wanted to make sure that I was really clear on what I was talking about, despite the fact that, I'm not giving anybody advice. So here's what happened. Gordon Price was part-time independent filmmaker, lives and works in Yorktown, Virginia. In February of 2017, Mr. Price and a colleague began filming an independent feature entitled Crawford Road about a stretch of road in York County, Virginia that has long been the subject of rumors of hauntings and was the location of unsolved murders. Mr. Price filmed some Crawford Road scenes in areas open to the general public at about 4 locations within the Yorktown battlefield in the Colonial National Historical Park, which is property administered by NPS. And when you go and read the NPS park policy, it says very clearly that national park sites belong to the public. So no issue about that. Mr. Price shot multiple scenes on the Yorktown battlefield, as well as at a location known as Crybaby Bridge along Crawdad Road. And I'm going down through Virginia. I'm going to have to go check this out when I get down south again, just because I want to see Crybaby Bridge. No more than 4 people were present during this filming, and Mr. Price used only a camera tripod and a microphone without any heavy equipment for his recordings in the park. Mr. Price, however, neither sought nor received a permit from NPS before filming on the battlefield. He screened the film in October of 2018 at a Newport News restaurant. So this is, over a year after he filmed. 2 months after that, 2 NPS officers located him at work and issued a citation for failure to obtain a commercial filming permit under 36 CFR subsection 5.5A. Price retained counsel and challenged his 36 CFR 5.5 violation on grounds that subsection 10905 was facially invalid as a content-based prior restraint of freedom of speech. The government elected to dismiss the charge rather than litigate the constitutional question, but it still maintained that the permitting requirements were constitutional and as such implied that Price would still be subject to potential future violations. The original complaint was dismissed. On December 9th of 2019, Price filed a civil complaint in federal court challenging the facial constitutionality of the permitting regulations and asked for a declaratory judgment stating that the requirements in 54 U.S.C. and 10905 43 CFR Part 5 and 36 CFR subsection 5.5 that those engaged in commercial filming must obtain permits and pay fees are unconstitutional. USC, by the way, is the United States Code. Sorry. USC stands for United States Code. CFR is Code of Federal Regulations. This is all, law stuff, basically. So Price wants a permanent injunction that would eliminate prosecution and the imposition of criminal liability under the existing law. He alleges in his complaint 6 reasons why 54 USC subsection 10905 and its implementing regulations violate the First Amendment. Price also alleges that 54 USC subsection 10905 and its implementing regulations violate the equal protection component of the Fifth Amendment. His contention is that filming a movie constitutes expressive speech protected by the First Amendment. Section 10905 and its implementing regulations restrict speech in public forums. So the court grants his cross motion for judgment on the pleadings. And the court issued a declaratory judgment stating its requirements in those codes that I keep repeating the numbers, that those engaged in commercial filming must obtain permits and pay fees are unconstitutional under the First Amendment. The court will also enter a permanent injunction enjoining the permit and fee requirements for commercial filming and enjoining prosecution and the imposition of criminal liability thereunder. In issuing this injunction, the court observes that a more targeted permitting regime for commercial filming, which is more closely connected to the threat posed by large groups and heavy filming equipment, may pass constitutional muster in the future. That was their ruling on January 22nd of 2021. And so it invalidates a law where applicability necessarily turns on an assessment of whether the content of a film was meant to appeal to a market audience and generate income. And all of that sounded like a slam dunk until the decision was reversed on appeal on August 23rd, 2022. And so the National Park Service issued interim guidance on 2/22/21 and said that they announced their interim guidance on that date in response to Price v. Barr regarding the management of filming in park areas. So under the guidance, they were going to allow low impact filming where basically you were, using one handheld tripod, and you could do that, until it got overturned on their appeal. So it was rescinded following the appeal in 2022, and now we're back to the original rules, which say federal law requires a permit for all commercial filming, no matter the size of the crew or the type of equipment. This includes individuals or small groups that don't use much equipment, but generate revenue by posting footage on websites such as YouTube and TikTok. The primary focus of the NPS, however, is on commercial filming that has the potential to impact park resources and visitors beyond what occurs from normal visitor use of park areas. Examples of this type of filming are productions that are substantial equipment that use substantial equipment such as sets and lighting, productions with crews that exceed 5 people, and filming in closed areas, wilderness areas, or in locations that would create conflicts with any other visitors or harm sensitive resources. And all filmers, no matter the size, must comply with all rules that apply in park areas, just like other visitors. So there are a couple of problems with this regulation, the way it's stated on the National Parks website. And one of them is that they're targeting YouTubers and TikTokers. And whether, apparently, from other things that I've seen, whether those users are monetized or not, which is kind of interesting, based on the premise that the platform is earning revenue, even if the creator isn't. So a little bit of issue around that. But they're very, very clear that the primary focus, I'm going to read it again, the primary focus of the NPS, however, is on commercial filming that has the potential to impact park resources and visitors beyond what occurs from normal visitor use of park areas. So, for example, you, I, or anyone else can walk through any national park and film whatever we want to, as long as we don't publish it where it could potentially earn income for anybody. But as soon as, so let's say you go to a national park and you film something and you put it up on, like your TV screen at home and share it with your relatives. That's a permitted use. No problem. Nobody's going to come cite you for that. It's perfectly okay. But if you turn around and load it onto YouTube so that your other friends and relatives that weren't in your living room when you showed it on TV can see it, well, now you violate it. Does that seem appropriate? It kind of doesn't, does it? And I think that NPS is, in their wording, is allowing an out so that they have the option to maybe not issue a citation. So there's that, okay? Now, then I started digging even deeper. So I found at nps.gov/subjects/policy MP8 use of parks. So in accordance with Public Law 106 to 206, still photography, whether commercial or non-commercial, will not require a permit unless it takes place at a location where or when members of the public are generally not allowed, or it uses models or props that are not part of the location's natural cultural resources or administrative facilities, or the Park Service would need to provide management and oversight to prevent unacceptable impacts. Notwithstanding the above policies, commercial media coverage of breaking news never requires a permit. However, it is subject to the restrictions and conditions necessary to protect both park resources from unacceptable impacts. So I thought that was pretty interesting because when you read that, still photography is fine, whether it's commercial or non-commercial, as long as it's public areas. So you're not like going into a closed off area to do your still photography. And you're not going to use models and you're not going to set up props or sets or any of those things. You're just using the natural or cultural resources that are at that facility. And that you don't need any intervention from the Park Service to manage or oversight to prevent unacceptable impacts. So again, we're back to I'm using my phone camera or whatever, my handheld camera. But then we get to the commercial media coverage of breaking news never requires a permit. Okay, now this is, again, this is from their policy page use of parks. So then I started digging into First Amendment activities because remember, back in the Price v. Barr, that's what their lawsuit was based on, that that he was conducting a First Amendment activity, even though really he was making a commercial film, because part of his subsequent complaint, I think he actually filed an additional appeal, is that he's not able to distribute this film and monetize it because of it, and he ended up having to recut it, re-edit it, do a whole bunch of stuff to take out the subject scenes that were potentially a problem. Anyway, let's talk about First Amendment activities. In section 8.6.3, we're still in the use of parks page. So in section 8.6.3, First Amendment activities, the National Park will authorize the use of parkland for public assemblies, meetings, demonstrations, religious activities, and other public expressions of views protected under the First Amendment of the U.S. Constitution in accordance with 36 CFR 2.51 or 36 CFR 7.96 to ensure public safety and the protection of park resources and values, and to avoid assigning the same location and time to two or more activities. The service may manage these activities by issuing a permit to regulate the time, location, number of participants, use of the facilities, and number and type of equipment used, but not the content of the message presented. So, and that's may issue a permit, not has to. So in a whole bunch of other reading, I found that if you are, if you're going to do a demonstration of a First Amendment activity, there are specific First Amendment sites set aside within the park. 25 people or less, you don't need a permit. Interesting. But digging deeper, I found the reference to RM 53, which is Reference Manual 53, which says, among many other things, there are also First Amendment issues associated with photography and filming activities. Please refer to 36 CFR 5.5 and Appendix 13, Filming and Photography. That led me to look at 36 CFR 5.5, where I found commercial filming and still photography activities are subject to the provisions of 43 CFR Part 5, Subpart A. Failure to comply with any provision of 43 CFR Part 5 is a violation of this section. And when we look at Subpart A, we find, when do I need, so this is subsection 5.2, when do I need a permit for commercial filming or still photography? And you can see why this is all very confusing for people, right? Visitors do not require a permit for filming or still photography activities unless the filming is commercial filming as defined in subsection 5.12, or the still photography activity involves one of the criteria listed in subsection 5.2b. So let's go look at subsection 5.12, where subsection 5.12 is defining all of the terms that on which all of these policies are based, okay? So in subsection 5.12, we find news gathering activities means filming, videography, and still photography activities carried out by a representative of the news media. Okay, so what's a representative of the news media? It means any person or entity that gathers information of potential interest to a segment of the public, that's you guys, uses its editorial skills to turn the raw materials into a distinct work and distributes that work to an audience. Well, guys, isn't that exactly what I do? every single day in every single video. I go out and I film things that I believe will be of interest to my viewers, that would be you guys, and then I edit it in a way that I think is going to best present that, and then I publish it. I think it's pretty much First Amendment protected rights. I'm curious, what do you think? I'm really curious if you stuck through all the way to the end on this one. I know it was, fairly fast, a lot of numbers, but no math. And I just thought it was kind of an interesting conclusion, and I'm glad I went through the exercise. I hope you enjoyed it. As always, thanks for watching. Leave a comment down below. Let me know what you thought. Give me a thumbs up if you liked the video. And yeah, we'll see you the next time.